Let's get started on our last of the John Marshall opinions. This is Gibbons versus Ogden. So we'll start off the same way. By the end of our discussion, we want you to be able to understand the players, the issue, the facts of the case, how that creates a legal issue, how the issue gets resolved, and why. Talking about legal rules and theories of interpretation. So, what do we need to know? Robert Fulton invented the steamboat, and this was a big deal back in the day. I know it seems like kind of antiquated technology now, but this was a hugely important way to transport not just people but goods in the same way that we use trucks to transport goods today. And Fulton partners with Robert Livingston, who's a New York politician and signer of the Declaration of Independence. And the two of them go into business together. And shocker, because of Livingston's connections, he gets the state legislature in New York to grant them a monopoly on steamboat traffic into New York City. And then Fulton eventually sells the monopoly to Aaron Ogden. So who is Mr. Gibbons? Thomas Gibbons ran a passenger ferry from Elizabethtown, New Jersey to other ports in New Jersey as well as Staten Island based on a license he obtained from the federal government. And that licensing system was established by this 1793 law called the Coasting Act. And Gibbons shows up in New York Harbor. He says, I don't care that I don't work for Ogden's company. The federal government has granted me this license. I'm going to use it. And Ogden takes him to court. So the issue is, does the Commerce Clause authorize the federal government to grant licenses to coastal vessels doing business across state lines? Now, I want to sort of be upfront with this is a fairly narrow way to constrain the issue in this case because, I guess at the end of the day, we don't really care what happened to coastal vessels in the 19th century. That doesn't necessarily help us understand constitutional issues taking place today that don't revolve around steamboats. But the importance of this case is sort of located in the broader debates that Marshall engages in about how much power the federal government can use, when it can use it, and what constitutes commerce. All of those things come into play in this case and in ways that make it relevant, not just to disputes over coasting vessels. So yeah, as I sort of highlighted, the court tackles three broad principles. What does commerce include? When does Congress gain the power over commerce? And then how much power does Congress enjoy over commerce? And as part of this, we're going to talk about limits on the commerce power, internal limits that you can find from within the clause itself, or we can talk about any external limits imposed by other parts of the Constitution. We're going to talk about how much power, describe how much power there is, but also what limits there are so that we understand how much power there is not, if that makes any sense. So, here's the clause itself. The Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Article 1, Section 8. Remember, there are 17 of these clauses outlining the powers that Congress has. And then the 18th clause is the necessary and proper clause. Necessary and proper was really important to McCulloch, but Marshall is going to be able to propose a solution to this case just by using the Commerce Clause, not also roping in the necessary and proper clause. So, what does commerce include? And Marshall starts off addressing this issue with another sort of linguistic argument. And it's one that's kind of similar to what we considered in McCulloch versus Maryland. Marshall writes, in Gibbons, Marshall writes, the subject to be regulated is commerce, and our Constitution being one of enumeration and not of definition, to ascertain the extent of the power, it becomes necessary to settle the meaning of the word. Um, to enumerate something means to have a list, probably a numbered list. Numer, right, is in there, and not of definition. Um, and I think kind of what Marshall's saying here is that provisions in the Constitution are not to be very strictly and narrowly interpreted, because if we had this sort of narrow understanding that the federal government can do this and only this, we learned how the necessary and proper clause complicates that. In McCulloch, we talked about how there needs to be discretion given to members of Congress to define whether a particular goal that a policy is trying to achieve falls within one of the powers given to Congress, and that so long as Congress's determination of that connection seems pretty reasonable, then the courts should stay out. So, what are the sort of contending definitions of commerce? Because Aaron Ogden's lawyers are going to try and argue for a very narrow understanding of commerce, and Marshall's going to rebut it in a way that is much more expansive. So, the counsel for the appellee, and that is Ogden, who enjoys the New York monopoly. Ogden would limit it, meaning commerce. Ogden would limit commerce to traffic, to buying and selling, or the interchange of commodities, and do not admit that it comprehends navigation. Navigation means transporting goods or people across state lines, and that's different than the buying and selling. The buying and selling might take place after the navigation is done, but it isn't the buying and selling itself. So when you think of what Ogden means by traffic and buying and selling, think of it in the modern sense that we use the word drug trafficking, the buying or the selling of drugs. Although if you're going to traffic drugs, you also better be good at navigation too, to get it to your source. So here's Marshall's response. This would restrict a general term applicable to many objects to one of its significations. In other words, commerce, if commerce meant only trafficking, the Constitution would have used the word trafficking, or would have specifically said that, the Congress shall have power to regulate commerce among the states, comma, by which we mean trafficking. But it doesn't. It's a general term, and therefore there are many different ways in which, or features of what is commerce. Trafficking is an important part, but it can't be the only thing that commerce covers. It's one of the significant parts of what commerce is, trafficking, but it's not the only thing. So, what does Marshall propose as a definition? Commerce undoubtedly is traffic, but it is also basically something more. It is intercourse. Now, I'll give you one chance to get this all out of your system, like it's third grade sex ed class again. But the way in which we use intercourse today is very different than around the time this case was decided. When Webster's Dictionary, that was created around the time this case was handed down, defines intercourse as literally a running or passing between. And what that means is it's communication, commerce, connection by reciprocal dealings between persons or nations, either in common affairs and in civilities, in trade, or correspondence by letters. We have an intercourse with neighbors and friends in mutual visits and in social concerns. And nations and individuals have intercourse with foreign nations or individuals by an interchange of commodities, by purchase and sale, by treaties, contracts, etc. It's basically the extent of a relationship. And that relationship can be economic, right? Yes, it can be, friendship by visiting your neighbors and your friends. But the more general understanding of the term is, a running or passing between people or goods, but in a way that creates a relationship between the two things. So what does that mean? Does navigation fall under the definition of commerce once we define commerce as intercourse? And Marshall reaches a very sort of sweeping conclusion that the power over commerce, including navigation, was one of the primary objects for which the people of America adopted their government. Again, we've talked about how economically disastrous the Articles of Confederation were. Now, to what extent did the framers in Philadelphia talk specifically about navigation as one of the reasons why they wanted to adopt a new constitution? I'm not exactly sure, but the power over commerce was definitely something that the framers wanted to strengthen at the federal level through this new constitution. And he says, okay, so it's an important power, and to understand what it includes, we should to understand what is there, basically, is what this quote is saying. Then you should study the exceptions and that shows you where a power is, how high a power rises is based on what limits are imposed at the very top. That gives you a sense as to exactly how much power there is to begin with. So, Article 1, Section 9 prohibits Congress favoring the ports of one state over those of another. The Coasting Act and Gibbons' business is based on the notion that, it shouldn't matter if you're a New Jersey native or a New York native. You should have sort of equal right to compete for business, for goods being and people being shipped in and out of New Jersey and other points in New York. So Marshall's basically saying, okay, is the federal government blatantly favoring one state at the expense of another? And the answer is no. They are not trying specifically to destroy the New York monopoly in order to favor, people from another state, or steer traffic away from New York into another port in another state. So, if what Congress is trying to do doesn't fall into the exception that limits its power, and it's a really, really important thing underloading the entire reason why we adopted a new constitution, Marshall reaches the conclusion that the power to regulate navigation is as expressly granted as if that term had been added to the word commerce. In other words, when you think about what the Commerce Clause means, you should interpret the extent of Congress's power to be the exact same, regardless if you're tackling trafficking, intercourse, navigation, or any other sort of aspect or way you want to define commerce. The power the federal government has is the same, even though navigation isn't explicitly mentioned in the text of the Constitution. So when can Congress regulate commerce? Because we might have an expansive understanding of what commerce includes. We might be sort of warming up to the idea that the federal government has a huge amount of control, but it doesn't control everything commercial, right? It only commerce among the states, with foreign countries, and with native peoples. The subject to which the power is next applied is commerce among the several states. He says, okay, now we've defined commerce. Now let's move on to defining the word among, and it means intermingled with. A thing which is among others is intermingled with them. Commerce among the states cannot stop at the external boundary line of each state, but may be introduced into the interior. So what is he trying to argue here? So here is a map. All the gray area over on the left is New Jersey. These are the boroughs of New York City, and then these are other parts of New York. And so Newark, New Jersey would have been like right around here. I don't remember where Elizabethtown is. I think it's a little further south, right? And so the line goes from somewhere here in New Jersey to Staten Island, and then to other areas in in New York, and I'm not sure exactly what they are. So, what Marshall, from this previous slide, is trying to handle is an argument that Ogden's lawyers are throwing out there. They want to limit Congress's power by narrowly defining the word commerce, and they also want a narrow definition of the word among, as in among the states. And what they're basically trying to argue is it's fine for Congress to set up a licensing system for steamboats, so long as that license doesn't interfere with existing state monopolies. So, if Congress had, told the license told Gibbons that, okay, you can, move goods from one part of New Jersey to another. You might even be able to move goods and people from New Jersey all the way around to Connecticut, right over here in the east, if they don't have a monopoly set up. But the federal government can't force its way into New York, and even if it could, let's say that on a particular journey that Thomas Gibbons is taking folks from first stop is Elizabethtown, New Jersey, stop 2 is Staten Island, and let's say stop 3 is up in the Bronx, right? Could another sort of slightly less narrow way to interpret the word among is to say, okay, if you're not going to honor our state's monopoly, you can have some power, but it's only to regulate the part of the voyage that goes from one state directly into another. The fact that the voyage continues on to other parts of the same state, that can't fall within federal authority. It can only be regulated by the state government. And Marshall says, no, that does not meet the definition of being intermingled. The part of the journey that goes from Staten Island to the Bronx is part of it. It is intermingled with the rest of the journey, and therefore Congress has the power to regulate the entire thing. That's what among the states means, not just crossing the borders once, but anything that is, sorry about this, anything that occurs as part of that journey. So Marshall sort of expands this point by saying that the genius and character of the whole government seem to be that its action is to be applied to all the external concerns of the nation, and those internal concerns which affect the states generally, but not to those which are completely within a particular state, which do not affect other states, and with which it is not necessary to interfere for the purpose of executing some general powers of the government. Okay, so if Marshall wins on this issue of saying, okay, you can regulate all sorts of navigation activity, not just when it crosses state lines, but when it stays within a single state. Does that mean that nothing that is economic can be left to the states? And Marshall's argument is no. When you have economic concerns that are completely within one state and they do not affect other states, and basically that makes it something that the federal government doesn't need to interfere with, that is up to the states. However, what's up to the federal government isn't just sort of the literal, you can regulate at the border between two states, is any external concern of the nation. And this would be external means economic relationships with other countries, right? The federal government needs to be in charge of trade policy. Again, going back to the Articles of Confederation, you don't want individual states writing individual trade treaties. But the federal government is also in charge of internal concerns which affect the states generally. If there is a recurring economic problem affecting the states in general, right? that can be regulated by the federal government, even if a particular way and a particular I'm not expressing myself very well. The Even if something doesn't involve a physical crossing of a state line, if it is an issue facing many states to the point where it affects the states generally, it still falls within the federal government's power. You don't need a physical crossing of a state boundary to trigger its power. But whenever there's something that is truly local, it's completely within one state and it doesn't affect the other states, that's when the states are in charge of regulating the economy. I think this is where we're going to leave it, and we should be able to push through the rest of the slides and answer questions, hold a little bit of a debate next time. So thanks, you guys, and I will see you soon.